To begin with, I want to first understand, there was a panel discussion. Can you share some key takeaways from the panel discussion?
Key takeaway, first and foremost, is that Australia remains kind of neglected by Indian businesses and Indian arbitration law practitioners. It's a very thriving jurisdiction with very strong institutions, and we need to interact more, do more in Australia.
Right. Given India's goal to become arbitration hub, so what do you think, in your opinion, should be done to attract more international arbitrations?
Specialist court to start with. We did bring in commercial courts, but frankly, on ground, there hasn't been much change apart from the change in the nameplate. So specialist judges, more advocacy, more training, and fewer but very strong and well supported and funded autonomous arbitration institutions. There are just too many arbitration institutions. Every city has founded one, and each one of them, they are competing with each other. I think it's time for consolidation, fewer institutions, well funded, well supported, and completely autonomous.
Right. I think they all are great suggestions. Do you think we are lacking somewhere, or do you think after 5 years we'll be able to implement these suggestions? Are we going in the right direction?
No, there are proactive steps being taken, and courts have actually shown enlightenment and sophistication in that respect. Courts have been more proactive and more progressive than the government has been. DAW is an example. Delhi Arbitration Week is fully supported by Delhi High Court, completely planned and executed by teams constituted by the court, and the judges take a very active role in conduct of this seminar. And I think that more of that will happen and is happening as well.
You have seen the DAW since its inception. So after 3 years, after this is the third edition, where do you see how it has grown?
Well, DAW has become a USP for Delhi as a jurisdiction. And I can tell you that after I visit a lot of conferences elsewhere in the world, and this is one of the best organized conferences that I know of. There are no conflicting events. The panels are top quality.
Yes.
And all of them are always well attended. You saw the audience in our room, 8 o'clock in the morning on a Saturday. I think that's quite remarkable.
Right. Please tell me, in your experience, what are the most common types of cross-border disputes that Indian companies face?
You are in between India and Australia?
Yeah.
Okay. Between India and Australia, it will be more disputes in relation to commodity trade and interactions. Okay. So that's likely to be more often the subject matter of arbitration than shareholders dispute. With other countries and jurisdictions, shareholders dispute.
That's the most
breach,
common one.
Yes, compensation for breach of contract. These are the usual subjects litigated in arbitration.
Right, thank you. What is the significance of the seat of arbitration in international disputes involving Indian parties?
Well, Indian parties should be very careful in choosing the seat. Seat brings with it legal consequences. So seat is the center of gravity, as they say. In arbitration, the courts at seat have the supervisory role, and they are also the court of first instance for challenging the award. Right. And therefore, Indian parties need to be very careful in choosing the seat. They must ensure that it is a jurisdiction which is impartial, fair in its treatment to foreigners, and it is cost-effective and efficient.
Right. Final question. If you have to define Delhi Arbitration Weekend in one word.
excellent.
Lovely. Thank you so much, sir.
Thank you,
so much
Bhumika.
for giving
Thank
your
you.
time.